All right, thanks, Logan. President Trump's legal team, as we were talking, was dealt additional setbacks yesterday in a number of states. This as the campaign is pushing forward with a dual-track strategy of also attempting to get state legislatures to decertify their election results or appoint Trump electors. So let's take a look at where things stand less than 10 days before the Electoral College meets in Washington. We're joined this morning by Mark W. Smith, author and professor at the King's College, and Ameer Benno, attorney and Republican strategist. Okay, Ameer, to you first. Let's talk about Wisconsin. A conservative state Supreme Court justice in Wisconsin ruled against the campaign yesterday, saying that, quote, the relief sought is the most dramatic invocation of judicial power that he has ever seen. He called the evidence that was presented flimsy. Rudy Giuliani says there's incontrovertible evidence. Where's the disconnect here?
Well, look, there has been incontrovertible evidence. We haven't heard anything rebutting the evidence that Rudy Giuliani put forth in those hearings before the legislators and the legislatures and their committees. The disconnect is that the courts lack the spine to do what's necessary here. They are concerned about disenfranchising down ballot votes and voters, I should say. But the fact of the matter is there's proof of fraud. And so despite what the courts are deciding to do, the legislatures in the states can still take the action that's necessary if they want to take legislative action. But it's not limited to state legislatures. And that's important because when the Electoral College convenes on the 14th, different slates, if the victor of a particular state is uncertain, they can send different slates of electors to vote in the Electoral College. And ultimately what happens, and this has happened twice in U.S. history before, most recently in 1960, is under the Electoral Count Act, the Congress would have to be the ones, when they tabulate it, to decide which slate would apply. And they have to agree. That means that the Senate and the Congress have to come together, and that's why this election in Georgia is so important.
But Ameer, I have to ask, because the campaign has they're pursuing a legal strategy, and your contention is that there is plenty of evidence that would be outcome determinative. You believe that the judges see that, they just don't want to rule in favor of the campaign. They're minimizing that intent. They're minimizing that evidence intentionally.
Well, I think that there's a doctrine that applies to the courts when they can step into particular cases, and they tend to defer from doing that when it's a purely political question. These allegations of fraud, episodic allegations of fraud from different counties, you need to have a very high standard of proof, and you need to be able to show that it's a systemic problem. I don't know in the case that was presented in Wisconsin whether they actually crossed that hurdle. But the fact is like you mentioned in the intro here, is there are two tracks. There's a political track and a legal track. I don't think the legal track is going to turn on these fraud allegations. I think the legal track is going to turn on the constitutionality arguments. That is, that certain states allowed these mail-in votes to come in beyond the date that the legislatures had enacted as the last date.
Yeah, but Ameer, I mean, are you saying that in those states, those votes then would be outcome determinative? I mean, yes, there could be thousands that would be impacted, but is it going to change the outcome of the election? I want to move on to Mark. There were additional lawsuits that were thrown out for not meeting the burden of proof in Nevada. I personally was very surprised by that, because the Trump campaign has been very specific about dead people voting, folks that had moved, also in Arizona. Again, scathing rebukes of the campaign. Now, I know that the campaign says that they are trying to get to the U.S. Supreme Court with some of these cases, but from your readings of the decisions that have been handed down, some on the federal side that were even from Trump appointees, do you think that the Supreme Court is likely to take up any of these cases?
Yes, I think the Supreme Court's going to take up at least one of these cases and is going to send a message. I think it's very important for people to understand that Donald Trump is wisely undertaking a two-pronged strategy. Now, you have to think for a moment that there is a political component to this and a rule of law component. When it comes to the rule of law, courts are very good at certain things and very bad at other things. What courts are very good at is figuring out the facts of what happened. What legislatures or the political process are very good at is figuring out how to take steps to remedy a potential problem. So I think what the Trump campaign is doing, and I think it's actually pretty wise, is they're trying to pursue factual investigation and evidence in court to establish that what happened here with this election was not done according to Hoyle, that there were problems, maybe it was voter fraud, maybe there were irregularities, maybe there were unlawful conduct, any or all of the above. And then if they can establish that in court, then the Trump campaign could potentially look to state legislators and legislatures to make decisions about what the remedy is. So I do think this two-pronged strategy makes sense. And I think a guiding notion from the U.S. Supreme Court indicating that voting and election integrity is important and is something the court should at least be looking at is a fair point and would be something appropriate and I think will happen.
Sure, but Mark, I mean, and you made a very, very cogent point that you present evidence in court, but the courts are saying that the evidence is insufficient. You're trying to leverage evidence in court to influence the state legislature, but the courts are saying that the evidence is insufficient. Ameer, a lot is being made this week about the Georgia video. Purportedly shows boxes of ballots being counted in Georgia with no observers. They look like they were just sort of taken out of suitcases. Do you think that that's going to be reviewed? And is that something that could ultimately do what Mark is saying and sort of force the legislature's hand in Georgia or perhaps in another state?
Well, I think that is an important video to keep public interest and keep this in the public eye, because there's been a mainstream media blackout on this. And when we talk about, it's certainly enough evidence to warrant an investigation. That's what that video is. You know, you think back to 2.5 years of a Russian collusion investigation that ultimately yielded no evidence of Russian collusion. And here we have what at least purports to be untoward activity and something improper, but yet there's been no investigation and there's been a media blackout. So by focusing on this and by bringing it into the lawsuits, I agree that not only can we get more evidence about what took place and take issue subpoenas, which you can't do without the lawsuit, by the way, take depositions and gather evidence, but you keep it in the public eye and you keep public sentiment aware of this issue so this doesn't fall through the cracks or get missed.
Yeah, you know what? And this is also sort of a longer play, really, than just December 14th in terms of fixing our elections. I should point out that the Georgia Secretary of State promptly this week dismissed that video as not being clear and convincing evidence. Mark W. Smith and Ameer Benno, thank you for joining us and helping us break this down.
Thank you.